Do you need a shareholders agreement? Hi, I'm Caitlin Bowman and I'm a senior lawyer in our business and property team here at Turnbull Hill Lawyers. I'm speaking today about companies and specifically about shareholders agreements. Are you a director or shareholder in a company where there's more than one shareholder? Or do you have a shareholders agreement in place for that company? If not, or if it hasn't been revisited by the shareholders since a change in ownership or structure, then this may be for you. When a company is incorporated, it's governed by its constitution. This, however, does not set out the rights and responsibilities of the shareholders of the company. A shareholders agreement will do this, as well as provide the foundation of governance for the shareholders and outline what a shareholder can and cannot do. A shareholders agreement provides a well-considered structure for the company's operations and establishes clear guidelines for shareholder responsibilities. It assists with decision-making and minimises the likelihood of disputes among the shareholders. So consequently, this means that the company benefits from a smoother, more profitable management process. Whether you're a minority or majority shareholder, having a shareholders agreement offers numerous advantages. It safeguards your interests as a shareholder. It ensures all shareholders have a mutual understanding of the venture and the business. It provides clarity regarding the extent of your rights and obligations. So there's several typical type of clauses we'd suggest your shareholders agreement should contain. The first one would be director appointments. So what rights do shareholders have to appoint directors and possible situations in which they might lose that right? For example, if their shareholding falls below a certain percentage. Second, the management and how decisions are made, how often the directors and shareholders would meet, which decisions would require a majority resolution, so 50%, which would require a special resolution, 75%, or is it a unanimous decision, or other type of approval process. Thirdly, dividends, how and when dividends would be declared and issued. Fourth, the transfer of shares and how this would occur. For instance, is there a right of first refusal or preemption to current shareholders if one wants to leave? And finally, the exit strategy. So what happens and what is the process when a shareholder wants to leave? Is there a set value or a methodology to find the value? Each company's shareholder agreement contains unique clauses and processes that are tailored to its specific circumstances. Therefore, we would always suggest that you have an experienced commercial lawyer draft the clauses to ensure they accurately represent the needs of all members, including minority shareholders. If you require legal advice about your company or a shareholders agreement, feel free to contact us here at Turnbull Hill Lawyers.